Well, this is the second in our two lectures on criminal law in Chapter 6 here. And in the first lecture, we got through some of the types of crimes, and we got through just some general explanation. Remember that when we study criminal law, we look at two aspects. We look at criminal procedure, which is the process of the criminal justice system. And then we look at crimes and philosophical issues surrounding those. So why is this a crime and not that, and how are those things prosecuted? And so we went through a little bit of background on the criminal justice system. We looked at some differences between the criminal justice system and the civil law system, where in the criminal system the case is brought by who? Who brings the case in a criminal situation? Luke, who brings that case? The government, okay, and sometimes we call that person there's a bunch of different terms for them. Anybody help them out? What do we call that person? The state, okay, but who's the person that actually argues the case on behalf of the government? The attorney general certainly could, the prosecutor, the state's attorney. There's a number of different terms that we would use, the district attorney sometimes, and so those are all basically talking about the government that brings this case against an individual. And so that's the criminal law system. Now, what I want to pick up with today is looking at different types of crimes, and then we'll look at some defenses and some of the more fun cases and things that the book gives you for examples. So, in looking at different types of crime, we find there are violent crimes. We looked at that as the last thing of our time together. We looked at violent crimes. Then we looked at property crimes, thefts and destruction of property. And now we look at white-collar crime. Now, why do they call it white-collar crime? Well, the idea is, and I had my criminal procedure professor in law school always would say, criminals are always portrayed in the movies as these, mastermind, evil genius types. He said, reality is the intellect of the person who decides, what would be a good way to get money would be to steal it from someone else or commit a crime, is usually not like your high IQ types of citizens. And because of that, most crimes are bungling messes, where they can easily be solved and they can easily figure out who did it and prosecute the offenders. The reality is, however, that there is one echelon of criminal behavior that rises above that intellectually a little bit, and that generally we call that white-collar crime. And the idea here is that through nonviolent means, a person would be able to steal or obtain favor in the case of bribery. They would be able to steal money or trade secrets. You hear about corporate espionage and things like that. And so there is this side of the criminal justice system, and this is probably the side that impacts business more than any other facet of criminal law. So we'll park here a little bit, especially talking about embezzlement. Okay? Now, embezzlement is a special kind of robbery. Okay? And I use the term robbery in its generic sense, in the sense that you're stealing money from someone else. But embezzlement is special. It's different. Okay? And the difference between embezzlement and your general run-of-the-mill mugging, okay, or sticking up a 7-Eleven, the difference is, with embezzlement, you were trusted with possession of that resource, of that money. So in Bible terms, we would call that stewardship, right? There's a person who's an owner, and they have money, and they give it to you, and they say, listen, this is still my money, but I'm asking you to do something with it. All right. So the example in business is you are an accountant or a manager for a company, and so you are the one that is required to properly pay the bills and pay the right bills in the right amount to the right people at the right time. Okay. That's all of accounting in 4 steps. Okay. You're welcome. All right. Just simplified that for you, and so the rest of your accounting career should be a breeze after that. All right. Just pay the right people, the right amount, the right time, and you're good to go. And so that's the job that you've been given. And in order to pay those bills, you have been given signature authority on a checking account that actually belongs to someone else, right? So you are, on behalf of the business, authorized to write checks. And so the example would be over at Eternal Vision, the foundation where I try to help Christian schools and colleges and students and things like that with grants and things like that. Through Eternal Vision, I have signature authority on some very large accounts. Over $1 million in this account, and I could go and I can write a check. Would there be anything illegal or mechanically wrong, in other words, in the process of me writing a check on that account? No. So I have legal authority over that account, over those funds. But there's a catch, right? And the catch is, it's not actually mine. Is there anything wrong with that? So I'm possessing something that is not mine. Sounds like stealing, right? Hey, that's my bike. Give me that back. You are possessing something that's mine. Give it back. That's stealing. Why is embezzlement not stealing? Because I have been given that by consent to do a job. When do I cross the line between what is perfectly right, and in fact, business could not exist if we didn't have a way legally to transfer these rights and responsibilities. It's called agency law. We studied it last semester. Business couldn't exist. Corporations can't do anything unless people do it on their behalf. So when do I cross the line between what is essential for business and what is going to be criminally prosecuted? Well, you better figure out the answer to that question, because most of you in here will someday be in this role, right, where you have to act on behalf of some other business. Well, I cross the line when I fail to follow the instructions. Okay? When I'm given that authority, it comes with limits. One of those limits is I am to use those funds for the legitimate purposes of the business or the owner. I'm supposed to follow the instructions. And so if the owner says, Matt, go down and buy yourself a new truck and just write a check out of the business account, and I go down and do that, have I stolen from the business? No. Why? Because, wait a minute, you personally benefited from, you wrote a check and personally benefited from that? That's got to be stealing. That's got to be embezzlement. Why isn't it? Because the owner told me to do it. But change just one little thing. Instead, I get to the end of the year and I think, man, I have done a good job as the accountant for this company. This is the most profitable year they've ever had. This is amazing. And it's really, I mean, I hate, it's not my style not to be humble, but really it's because of me. Okay, I mean, that's the reason why this company is so profitable. And the owner is never going to notice that I've done all this. And so what I'm going to do is, I've got signature authority anyway, I'm just going to go down to the car dealership, buy myself a new truck. And there's nothing stopping me. I have signature authority. He can call the bank and check on it. And they'll say, yeah, he's authorized to write those checks. But I decide for myself to go down and buy the truck. Have I crossed the line now? Same exact facts, except I only changed one little thing. What did I change? The owner didn't authorize that. That's the crime of embezzlement. Now, I'm giving you two very clear examples that show clearly on one side of the line, clearly on the other side of the line. Unfortunately, in life, it sometimes isn't so clear, evidently, because I got a lot of cases, and even involving churches, where you have the church treasurer, and over time, you so personally identify with the business or the ministry that you forget it's not the same thing. You forget that access to use these funds on behalf of the ministry or the business is not the same as ownership, and you forget that. There's some sort of an effect on your brain that takes place after so many years of routine processing. So A, be very careful about that attitude in your own mind, and B, watch for that in others. When you see a church treasurer that start talking about my or our, or when wait a minute, what's up with the personal pronouns? Okay, that always makes my little spidey sense go off whenever I hear someone that's in charge of someone else's money referring to it as mine, okay, or I decided, or oh really? Did we forget that we're stewards here, okay? Did we forget that it's not ours? That's a big flip. And I mean, I've handled big cases, and over time, you realize, something big is going on here. I'll give you one example. A church, actually it was here in Wisconsin many years ago before I even lived here, and the guy who counted the offering was slipping cash out of the offering. Now that's the most simple, non-intellectual version of embezzlement there could be. I mean, you have cash in the offering plate and you pull it out and put it in your pocket before it can ever get counted. And that was kind of what he started doing. Then he realized, I'm the only one counting the offering. Anybody see a problem with that? You should always have at least two people counting the money, all right? Never let yourself be in a situation where you're the only one in the room with cash, okay? That's dangerous. Don't do that. You're leaving yourself open to a needless accusation when that happens. So he's in there counting the money by himself, and he says, this is just too easy. Well, come to find out, over the course of about 7 years, he was not just slipping some cash. He started taking all the cash. And so the only thing that would ever get deposited was the checks. Well, after a while, the church decided, we really should have two people in there counting the offering. And so for the first few weeks, the pastor was amazed because the stewardship in the church just went through the roof. I mean, the offerings just went sky high, way over their last 2 or 3 years average, because all of a sudden it was getting counted before the guy could figure out a new scheme. So then he figured out, well, here's what we'll do. Instead of making the whole deposit this week, what I'll do is I'll hold back some checks. And then next week, when the multiple guys count the offering, I'll find out what the total is, and then I'll take all the cash, put that in my pocket, and use the leftover checks from last week to make up the difference, to get as close as I can to the total that they came up with. And then if I need $1.29 to make it exact, I'll put that in the deposit, and then I'll make the deposit. And when they go to check the deposit slip, the total will be the same as the count. But in the meantime, he's taking all the cash. Well, if you figure out the math and the logic there, it's not exactly the greatest scheme ever, because a quick check would easily figure that out if you just compared the cash deposit total to the checks. And the way it got caught 5 or 6 years later, after literally hundreds of thousands of dollars is probably gone from the church, is that the guy went on vacation. Now, one thing you should know about embezzlers, as church treasurers especially, is that they're very faithful. They never go on vacation. All right, I mean, they will be there every single service, day in and out, and you will praise them for that. Wow, you are like so faithful. I mean, you never are sick or miss. You come in when you're sick. This is unbelievable. Well, there's a reason for that, because this guy goes on vacation, and one of the deacons steps in and tries to help out. And he starts to get suspicious about some things, because the bank calls him after Monday. He makes a deposit, and they said, "Oh, you guys decided to have a cash offering this week. That's cool." And he thought, "What?" And they said, "Yeah, well, it's been 5 years or so since you've deposited any cash, and we always called you the no cash church down here at the bank, And he was laughing about it. And the deacon's thinking, "This is the weirdest thing. I mean, why is this a joke? I don't get it. There's always cash in the offering. What is this guy talking about?" Oh yeah, and it took them a while to figure out they weren't joking, that they were serious, that they really thought it was unusual that after 5 years of no cash, there was an offering half and half. And he said, we need to start digging in. So he goes back and starts to look at the past receipts and find out, oops, okay. Now, there's a whole host of other kinds of embezzlement. One of them is the fictitious payee, right? And so one of the ways that you can... and this is not a how-to, all right? I'm giving you, some of you, I'm leaving out critical steps that will make it successful, okay? And I'm not going to tell you those things, so don't try any of this at home, all right? It won't work on your wife someday. It won't work on your husband, all right? These things are not good. So what you do is you mock up an invoice from a company that doesn't exist, and then you pay that company the bill. And so if you did a quick audit, you would see the substantiation in the files. Okay, yeah, they paid ABC Lawn Company. Well, there's no such thing as ABC Lawn Company. And so you've paid for a service, and this happens with internet stuff, with utilities. You make up a fictional service that you're not actually receiving. You pay that company. Then you go and sign over that check on behalf of the fictitious company to yourself, and you go deposit it. Now, once again, paper trails are pretty easy to follow on these to figure out who had it, but they're counting on that no one will ever go back and check. And so there are many kinds of embezzlement, many kinds of schemes that are out there. And certainly, they are all criminal and will be prosecuted that way. It is interesting with embezzlement, think about it, because embezzlement always involves a breach of trust. It's not like a mugging where you've never seen this person before in your life and you'll never see them again. I mean, that would be emotional, right? To get anybody ever? No, I don't want to ask that. But if you've ever been robbed, I mean, that would be emotional. But it's not nearly, in my experience, as emotional as an embezzlement. People, when they find out they've been embezzled, are so angry that literally you see a lot of murders come after people find out that they've been victimized of embezzlement. Why? Because you knew that person. Listen, by definition, the embezzler is the last person you would ever think is going to steal from you, right? It'd have to be. Why would you give money to someone to entrust them with that if you thought maybe they might be stealing from you? Of course, it's a trusted person. It's someone that you know. It's someone that you like. And you've given them your checkbook, and they stole from you. So the emotion involved, the betrayal involved in an embezzlement is extreme. And oftentimes you will see violence come, but actually back on the person who did the embezzlement, because it's just a completely different kind of crime. You are looking them in the eye and stealing from them at the same time. And many times being paid to do it, which is kind of insult to injury. So embezzlement is there. Mail and wire fraud, those are all federal crimes. In other words, if you use the mail system or the electronic wiring system to do or move any funds, then that is a separate offense that can be prosecuted. Bribery, we've talked about in some other chapters. Theft of trade secrets in terms of business. Insider trading, ask Martha Stewart about that one. That is, you find out something from an internal company source, and you act on that in an unfair way that gives you an advantage in the workplace, in the marketplace. And if that happens, then you can be guilty of insider trading. We'll look more at that in a next chapter. So we looked at your blue-collar crimes, your violent crimes, your property crimes, and we looked at the white-collar crime. Now we look at organized crime. And this is one of the most sophisticated criminal laws out there, and probably one of the least understood crimes out there. And it's called RICO, the Racketeer Influenced and Corrupt Organizations Act. And RICO, you don't need to know what it stands for, but you just need to know that acronym and know what the gist of it is. And RICO is what they use to go after the mob, okay? Go after organized crime. And the way that the mob traditionally would defend itself in court was by saying that the right hand doesn't know what the left hand is doing. Organized crime syndicates always need to have legitimate businesses attached to the syndicate. Why? Why would you need to have, you put on your evil genius hat here for a second. Why do you need to have a legitimate business attached to your criminal enterprise? So you're running guns or drugs or prostitution or human trafficking or whatever your organized crime, your illegal activity is. Why do you need legitimate businesses attached to that? You're going to help me out with this. Jared, why? Why do I have to have that? What could I use it for? Why would it be convenient?
Well, you just have to use this kind of like as a smoke screen, so you kind of look legitimate.
I got to explain this all as money, right? In a way. Good. I got to look legit. I got to get up and go somewhere in the morning. So they go down to the Italian restaurant. Okay. Go down to the dry cleaners. Okay. The club, the car repair shop, whatever. You've heard of a front organization? You ever heard of a front company? That's just a front company. What does that mean? It means that's the legitimate component, the supposedly legitimate component of the criminal syndicate. The problem is it looks and feels real. And the books are made to look like it's very profitable. But where is that cash really coming from? It's coming from the illegal activity, and we wash it through the legitimate business. And what do we call that washing process of money? Money laundering. Okay, that's where the term comes from. And so we are going to take the illegitimate money, put it into a legitimate business, cook the books. Okay, so we have cooking and laundry now, and it's all part of RICO. And so what RICO comes in and says is, you do not have to know about what the other parts of the syndicate are doing in order to be prosecuted for what the result is. You don't have to prove that this guy knew what someone else was doing in order to prove that he was related. And so in the mob, the traditional mob is one head with multiple different lieutenants and businesses. And so this guy, Criminal D over here, would claim he didn't know anything about what Criminal A did, and therefore he can't be held responsible for anything but what his own personal actions. And what RICO says is, no, we can take down the entire entity for what he did. And so that's kind of how that is used. One example of how RICO is misused, Morris Dees, you probably never heard of him, in the Southern Poverty Law Center, was a very important player in the civil rights movement, using legal tactics, civil kinds of cases, to take down companies that were discriminating. And so they would use these kinds of things. He got very good at using RICO to go after the KKK. And so he goes after the KKK and gets the Klan on its financial misdealings and would shut them down in a given state. And he'd go state by state. So the Klan hated Morris Dees. In fact, they tried to kill him a number of times. And he was a champion for civil liberties. Well, then he ran out of KKK opponents, and he started looking at other causes. And in more recent times, with RICO coming, getting a little more teeth to it, he decided, you know who we should go after is this pro-life crowd. And so somehow going from civil rights champion to now where they're trying to go after pro-life protesters. And so what he's arguing is, this guy out here on the corner in front of the abortion clinic with a sign saying, "Don't kill your baby," is part of the same criminal enterprise of Eric Rudolph, the bomber, who went into an abortion clinic and blew it up and killed somebody, killed a doctor or two or three. And so because Eric Rudolph did this crime in the name of this pro-life cause, and you are out there holding signs and passing out literature and raising money on behalf of the pro-life movement, you two are connected, and so we're going to try to take down your pro-family organization, your nonprofit organization. Yikes. Okay. Now that's an extreme example. That has not been successful, but that's been the argument. The other way that RICO is used now is in the anti-terrorism movement. And so it went from the mob, but then people said, there were other organizations that use this same kind of strategy. Let's use this to go after them too. And they said terrorists use the same thing. You got bin Laden, formerly, okay. He's now in a different place. But you got bin Laden here at the top, and you've got all these terror cells operating independently. And then off here to the right, you have nonprofit American charitable organizations that do nothing but raise money for pro-Muslim causes. Okay, perfectly fine, protected under religious liberty, protected under American law, for them to do that if they're raising money for legitimate means. But then you've got to trace some of that money and find out it ends up in terrorists' pockets. And you say, aha, you are actually part of this overall cause. And they could say, well, wait a minute, we had no idea that when we gave this money to these people, they were going to use it for that. Well, RICO puts an obligation on you to know. And so it's one of these things that, yes, it's good when it's used right, but whoa, is it really tough to draw the line as to what's right and what's wrong with how RICO can be used. It can be misused as well. Here's another thing about RICO. It has criminal provisions and civil provisions. So it can be brought by a prosecutor. You can be thrown in jail for RICO violations. And you can be sued privately by just a regular old attorney like me for a RICO violation. And I can pursue civil penalties, forfeiture, treble damages. That means triple. I don't know why we say treble. We just say treble. So we could say triple. You know, that'd be cool. That's more of a Star Trek thing. You're too young to understand that. It was back before special effects. Give us a break, all right? We use plush toys as enemies. All right. That's the trouble with triples. Nice. So we get treble damages. That means triple damage. Why would we ever in a law say, you know what, whatever the damages are, multiply it times 3, and that's what we give the guy? Why would we do that? Because we really, really want to punish it. That's the idea. So you get attorney's fees and triple damages. We want to give lawyers an incentive to go after these kinds of things. And what that does is it supplements the workforce. You realize there's only a certain number of prosecutors in the world, and they have lots of drug cases to prosecute. Evidently, that's what they mostly do. And so they are going after all the drug cases. They don't have time to mess with white-collar stuff. And so what RICO says is, okay, prosecutors, you don't have to be the only ones. We'll give regular old money-grubbing, greedy civil trial lawyers something to do, and we'll let them use RICO also. So it opened up a whole brave new world of litigation when they did that. So that's RICO. And it's very complicated. It's much more complicated than I'm presenting here, but I'm giving you kind of the broad overview of that. Any questions about RICO or any other white-collar crimes that we talked about so far? All right, moving on. More classifications. Every crime can fall into one of these two categories. Either it is a felony or it is a misdemeanor. Some people get this confused, but there's really no need to. Very simple. At least I'm going to make it that way for you here today. Just understand before you go out and practice law, you know, it does get a little more complicated, but until then, this is fine, okay? So this definition is fine for you at this point. A felony is a more serious crime. It's a crime that, in general, you will spend more than a year in jail, possibly, for committing it. Does it mean that if you're charged and convicted, but you get a 9-month out of a possible 10-year sentence, and the judge only gives you a 9-month sentence, that therefore that crime is a misdemeanor? No. Okay? The classification doesn't have to do with the sentence that you got. It has to do with the sentence that is possible for you to get for committing it. And so there is a felony, and that felony is something that is possible to be punished by more than 1 year. Okay? A misdemeanor is your less serious crime. Now, let me just say, it's greater than a ticket, okay? You know, you have out there the possibility of just getting a ticket or a fine, and that's less than that's not a misdemeanor, okay? You ever been convicted of a misdemeanor? Well, I got a speeding ticket one time on the way to church. You know, everybody always gets pulled over on County A going out to Calvary, and everyone honks on the way by and texts them, sucker, you know. God forbid there's ever 2 police, you know, because after you pass the first one and you kind of speed, you know, then you're like, yeah, I'm home free now because they're better than that. Oh, no, there's a second one. That would be the worst. But you get that ticket, right? And the shame that goes along with it. Is that a misdemeanor? No, most likely not. If you run from the police or you do something like that, it could be much worse. But your run-of-the-mill tickets and parking fines and things, those are not considered misdemeanors. Okay, that's another step down. But you got felonies and misdemeanors. Misdemeanors, less serious, punishable by a fine or jail time up to a year. So would it be accurate then for me to say, on a test or otherwise, that a felony is a crime that's punished by jail time, but a misdemeanor is a less serious crime punished by a fine but not jail time? Is that an accurate statement? No. Would it be an accurate statement for me to say that if it's possible for you to be imprisoned for any length of time, then that can't be a misdemeanor. It must be a felony. Is that accurate? No. It is possible to go to jail for a misdemeanor. I mean, I've heard people argue, you can't send me to jail. This is like a misdemeanor. Well, I know, but that's still punishable by up to a year in jail. Okay, it's still serious. It's just less serious. Okay. Now, felonies usually come with other kinds of things, even when you get out. Like you don't get to vote anymore, and you don't ever get to own a handgun or a gun of any kind. Okay. So there are other kinds of things that get stripped away from you permanently if you commit a felony. So, don't do that. Yes.
For a misdemeanor, does it mean, so if you were to spend the night in jail, that that's right?
Not necessarily, because as we'll see, you can end up spending the night in jail before you're even ever charged or even convicted. Now, let's say you were convicted of something and went to jail for that. Your sentence was 1 day in county lockup. Yeah, that'd probably be a misdemeanor. Okay, probably. Now, let me just go back and tell you where this comes from. Every state has a list of what the felonies are and what the misdemeanors are. And it's different from state to state. So Wisconsin's list is different than wherever you came from. Okay, if you came from Texas, it's way different. But I'm saying it this way, but how that gets interpreted in a given state is up to that state and its penal code. Okay, so I'm giving it to you generally here. You have to look it up in your state. Yeah.
Under misdemeanor, when it says by confinement, does that mean jail or prison?
Yes.
Is there two, three?
Not really. I mean, jail or prison just has to do with your assignment to a bunk by the Department of Justice. Okay. Prisons generally are used for longer confinements. If the conditions warrant it and the county has a facility that can accommodate longer-term prisoners, it will. Okay. So in Los Angeles, for example, they have notorious overcrowding, and the people who are on shorter-term stays for less than a year will actually never leave the county lockup. Okay, they don't even bother putting you in the prison system until your sentence is X number of long. But that's where you get assigned to actually spend your term in jail is an administrative function that's handled by the Department of Prisons within the Department of Justice of that state. Okay, so Illinois is an interesting example. They say the prison system refers to itself as a downstream system. In other words, we have to take everybody they send us. And if you think about it, that's kind of a bleak situation because no politician ever ran on the platform of more funding for the prison system. Like if I'm elected, I'm going to spend your tax dollars on better prisons. And it just never happens. And so I guess if you tried that, you probably wouldn't be elected. And so what ends up happening is that they get cut on their funding, and they don't have enough prisons, they don't have enough cells to offer enough bunks, and then the criminal justice system just keeps sending them people. Well, after a while, you say, we got nothing, and so then they say, well, you got that gymnasium, and so there are prisons in Illinois where there are like 50-some guys living in the gymnasium in bunks where they no longer obviously play basketball, but that's like your cell is the gym. All right, kind of like when Maranatha first started and our dads were roommates, and they had to, back in the day, those I had 47 roommates. All right, well, it's like the prison system is now. Okay, so there's other similarities. We won't go there. Just understand, you don't know how good you have it now. Okay, you just don't know. But you say, well, I don't know. My roommate does seem like a criminal. Okay, well, maybe that's what's happened. All right, so. That's a downstream system they have to take. Usually where the balance comes is that the courts say it is constitutionally required that you provide humane conditions. And so under court oversight and mandate, they actually is usually what it ends up breaking the logjam of the need for another new prison or additional and better facilities. All right? Okay. Let's look now at defenses, okay? God forbid, but you've been charged with a crime, and now you need to know how to defend yourself, okay? Well, we'll look at 8 defenses. There I'm sure are more, but we'll just look at 8 of them today. First one we look at is self-defense. All right, justifiable force. What is justifiable force? Well, it means that you had a reasonable apprehension that you were about to become a victim of a crime. Okay? Now, the level of force is usually broken down into two categories: deadly and non-deadly force. So, using your hands, assuming that you have not been certified as a deadly weapon, which probably most of us in here have not. Anybody in here already been certified? No? Okay. I was a green belt back in junior high, I must say. But I never killed anybody, not yet anyway, with my bare hands, I should say. You're like, what? And so most of the time, a fist fight or using some sort of non-lethal force would be considered that way. Now, deadly force is any time you discharge a firearm or any time you stab someone with a knife, okay, those kinds of things. Even if you say, I was aiming for his leg, I was just going to wing him, or whatever. Okay, if you discharge a firearm in the direction of the perpetrator, that's considered the use of deadly force, okay? Because when you pull the trigger, you're responsible for the consequences. And so, why does that matter? Well, it matters because in most states that have some common sense, and then there are other states like Texas and Florida where it's not as much common sense is applied to this. Well, I guess it just depends on how you look at it anyway. In most states, there's a breakdown that says you cannot use deadly force just because someone is stealing your stuff. Okay? So, after chapel, you go to turn around and get your coat off the back of the chair, and the person behind you has, taken your coat already, and they're walking away with it. And you pull out a, 44 Magnum, and you blow them away, all right? Hey, bring my coat back. Bam! And you try to miss the coat because it'd be awkward wearing a coat with a big old bullet hole and everything. So you just pop a cap in them right there in the chapel. All right. What's the problem with that? Well, it's just there's no balance here. We need a little closer connection between the magnitude of the harm that's being caused to you by this crime versus your defense or your reaction was just way out of balance. Okay. So normally there is some analysis of that. Now, where it kind of breaks down is in the middle of the night in your own home, right? Because y'all have been there. What's that? My wife has unbelievable hearing in the middle of the night in her sleep. I don't know how it happens. It seemed used to be that way, but then we had kids, and it was like any little stir or peep, and bam, she was out of bed and out there, which is great for me because I'd sleep through everything, and it was not a problem. Well, every once in a while you get that, hey, and I don't know about, most of you probably aren't married, but where's Justin? Is he here today? Justin, you're here. You probably have had this. My wife, there's a lot of implied sarcasm in a lot of things she says, a lot of unsaid, like, you stupid idiot, kind of comments. And I just hear it. I don't think she actually says it, you know what I mean? But it's usually, hey, you stupid idiot. Don't you hear that down there? What's going on, And I say, it's probably nothing. And the only reason I say it's probably nothing, it could very well be something. But the reason I say that it's probably nothing is because I don't want to get out of bed. And look, and statistically, it's probably nothing. It's possible we could all be killed in the next 5 minutes. But what am I going to do about it anyway? At least I might as well die comfortable, And so I usually don't want to get out of bed to go look, but you go down. Now, in my house growing up, we didn't have any weapons. My parents never had any guns or anything. But what they did have was a big wooden ball on the four-poster. They had a four-poster bed, that kind of came up about 5 feet, and they had at the top of it was a wooden ball, and it just had a dowel rod that kind of stuck up, and the ball went over it. And my dad figured out those things could come off, and so did we. It was a little bit. It was kind of the size of a duck pin bowling ball. Any of you go duck pin bowling? If you go, it's a East Coast kind of thing, but it's about this big, about the size of your head. And we used to roll those wooden balls down. My dad didn't like that, but that was his weapon of choice. Like if he had to get up in the middle of the night, he would pull one of those wooden balls off and walk down the stairs. So here's this dude in his bathrobe with a big wooden ball. Like bring it on. I'm gonna throw this at you or something. Would that be the use of deadly force? Probably not. Okay, so that would be fine. But if you were to walk downstairs with a gun and interrupt an actual robbery in progress in your home, okay? Now, normally, breaking and entering or robbery would be considered a nonviolent crime because nobody knows that you came and went, you didn't interrupt anybody, you didn't threaten them, and it'd be nonviolent. But now there's a confrontation. Do you have to wait in the dark and in your groggy, sleepy condition, figure out if this person has a weapon and is intending to hurt you? Or can you kind of infer by the circumstances that they broke into your house, this is your dwelling, and they're now in here in the dark where they're not supposed to be? Can you just go ahead and shoot or not? Well, the answer is, or the way to answer that is to ask yourself the question, am I in Texas? Okay, and if you can answer yes, I am in Texas, then fire away, all right? In fact, you can use an automatic weapon to do so if you like. Your house may suffer the consequences, but hey, go for it, because in Texas, defense of your castle, it's considered the castle doctrine, okay? And so your home is your castle, and you can defend your castle, all right? Kind of an interesting thing. Most states, however, take the position that there has to be something else, something threatening or menacing towards you or your family before you can exercise and use deadly force. Okay? Number next, necessity. Necessity. The example your book gives of this is that you have a situation where you're one of those felons, right? You previously had an unfortunate incident in your early 20s when you were a student at Bible college, and you now have a felony on your record. And so the rest of your life you are banned from possessing a firearm. And one day in your late 40s, you walk into the bank and unfortunately interrupt a robbery. And, of course, then your Green Beret training that you never had kicks in, and you go into action, and you tackle the robber, and you dislodge his handgun out of his hand, and you pick it up, and you hold it on him until the police get there. Uh-oh. Are you going to be charged with a violation of the terms of your release, and that you, as a felon, were not allowed to possess a handgun? No. Your argument would be necessity. There's a bigger picture here, Judge. I was doing the right thing. It was necessary. So yes, technically, I broke the law, but it was for a bigger, better reason. Now, you better be careful on this because the judge has to agree, all right, that it was really necessary, that there wasn't any other way around it. But that's the defense of necessity. And then everybody's favorite, insanity. All right, we talked about that a little bit in our ethics chapter, and the reason being that we do not want to incarcerate people unless they have the capacity or the ability to appreciate the wrongfulness of their actions. And the book gives you two different standards on this. You should get familiar with those. The McNaughton standard from the 1800s, and then the new kind of restatement of criminal law gives you a little different. The model penal code gives you a little different take on that. And the gist of both of them is because of your mental incapacity, you can't form the requisite intent to commit a crime. All right? It's impossible for you to appreciate the wrongfulness of your actions. And no amount of punishment or jail time is ever going to give you that capacity. You're just never going to know what right is from wrong. And so that's the concept with insanity. Sounds simple. It's much more difficult in real life to actually prove. All right? Mistake. Now, you've heard that normally ignorance of the law or a mistake is no excuse. But this is one situation where ignorance of the facts could be a defense. And so, for example, if in the case where I gave you before about the umbrella, where you took the wrong umbrella out of the lobby of the chapel, after chapel in the lobby of the gym? Did you commit a crime? No. Well, why not? Because you took someone else's umbrella. Why was it not a crime? Because you made an innocent mistake of fact. You did not know that that umbrella belonged to someone else. You thought that it belonged to you. So we try not to use the criminal justice system to punish people who are not bad people, who just made innocent mistakes about whether or not something belonged to them. Now, that, again, only goes so far, okay? It doesn't go quite as far as you might think, and it doesn't get used successfully nearly as much as you might wish. All right, duress. Duress means that you committed a crime, but you did so because someone was threatening you or your family member with violence. Now, it has to be imminent. In other words, close and realistic. It can't be me saying, listen, if you don't go out and rob the Quick Trip, then for the rest of your life, I'm going to crank call you, okay? And I'm going to call you at 3 in the morning. I'm going to call you at 2 in the morning. I'm going to call you at an inconvenient. I'm going to wait until you get it just right after chapel starts and you forgot to turn your ringer off, and I'm going to call you then. I will not let you rest. Can you say, well, it was duress, man. He was threatening me. No. Why? Because it was not an immediate threat of physical violence, okay? It has to be the proverbial gun to your head. All right. Now, even under duress, there is a limit to what you can do or be justified in doing. In other words, you cannot commit serious bodily injury to a third person to prevent serious bodily injury to yourself. So if the duress is, go kill someone, or we're going to kill you, then the law says you have a duty to die. We'll miss you very much. Okay? That's literally what the law says. It limits the harm. Because if you didn't say it that way, it would be awfully convenient, wouldn't it? You'd probably argue that in every case. So you cannot commit serious bodily injury or death to someone else because of a threat of serious bodily injury or death to you or a family member. It might make you a sympathetic person, but it's not going to be a defense. All right? Okay, that's duress. Any questions about these so far? I know we're kind of going quickly. All right, entrapment. How to explain entrapment in 30 seconds or less. Okay, entrapment means that the government made me do it. Okay, that's what the criminal is saying. This was a setup. All right? But if you think about it, there's nothing wrong with a setup, right? There's a sting operation. And, you hear about it all the time. So-and-so in Sheboygan today was arrested for attempted murder when they tried to hire a hitman to kill their husband. Turned out the hitman was a federal officer posing as a hitman, and as soon as the money changed hands, they turned around, informed her of her rights, and arrested her. Well, wait a minute. That's entrapment, right? You tricked me. You lied to me. I thought you were a hitman, and you were a government agent. What's the difference between a regular sting operation and entrapment? Because remember, if you're able to successfully argue this, you get out of jail. You're free. It's a defense. What's the difference? The difference is that it went beyond mere offer and opportunity. So the government is perfectly able to pretend to be a drug dealer on the street, and when you drive up real slow with the window down, say, hey, would you like to buy some drugs today, sir? They probably don't say it like that. And if they do, you should have some warning bells go off. All right. Hopefully there's some street lingo. I don't know what it is, okay? And you say, well, yes, how much are you selling it for? And they say, 25, and you say, sounds good. And then another guy comes around, pulls you out, and sends you to jail, okay? And they do this with drugs, they do it with prostitution, they do it with all kinds of things. That is merely giving you an offer, offering you the opportunity to commit a crime. And if you do, slapping the cuffs on you. That is different than entrapment. Entrapment is guys walking down the street, and they kind of grab him and coerce him and pressure him and over and repeatedly, and it gets to the point where it's like, look, just to get you off my back, here's $10. I don't care. And they say, ha, you're a criminal now. Boom, and you go to jail. So what's the difference? The difference is one person is looking for it, and given the opportunity, reveals themselves as a bad person. The other one is a generally good person that wasn't looking for it, that only did it because the government induced them to do that. And so the phrase in the entrapment law is, you were not otherwise predisposed to commit that crime. You only did it after pervasive pressuring by the government. And literally it was almost like, just to get them off my back, fine, I'll do it. Now, why would we want to have an escape clause, a defense in the law like entrapment? Why would we want to do that? Because I think we all hope the government has better things to do than to create criminals out of normal people, right? And the case that the Supreme Court used to do this was fascinating. It was a child pornography case, of all things. And they went after this guy. No one knows why they originally singled him out, because by all accounts he did nothing to attract their attention. But they just went after him, and for years pressured this guy to order child pornography through the mail. That's what made it a federal offense at the time. And it was just over and over, and finally he just said, fine, okay, send it to me, whatever. And then, boom, gotcha, haha. And the Supreme Court said, wait a minute, you are manufacturing criminals. That's not what we're looking for here. We don't have empty beds in the prisons that we're trying to sell. That's really not the goal here. And so entrapment is there as a very limited defense. It's very hard to prove. And in order to do so, you have to prove that you were not otherwise predisposed to the crime. So anybody that has a drug conviction in the past and then later on tries to argue entrapment in a second drug offense, forget it, okay? The government's going to say, Your Honor, I mean, even without us, before we were ever involved, this guy already had a record, okay? Oh, okay, well, there's no sympathy there. So you have to prove that you weren't predisposed. You have to prove inordinate amounts of pressure on you, and it was more than just offer and opportunity. All right, next thing, statute of limitations. Most crimes, except what we call capital crimes, and I'll get to that in a minute, most crimes actually have a statute of limitations, which means that after a period of time, they can no longer come after you for that. So burglaries and robberies and embezzlements and thefts and arsons and things like that, all of those regular crimes have a statute of limitations. It's usually 8 to 10 years. So it's a little longer than the civil statute of limitations, but it still exists. There has to be a point at which we kind of clear the books, right? Say, okay, enough is enough, because everybody wants to tell their story, and after a while, you finally can, okay? So that's the statute. What is a capital crime? It used to be a capital crime was one that you could be put to death for. But that term is used a little more broadly now because hardly anybody does that anymore. And so the term is actually now meaning it's so serious, the top level seriousness of offense. So you have things, obviously murder is a capital offense. But you would also have some kinds of child sexual abuse are now considered capital crimes. And so for a capital crime, there is no statute of limitations. So they could come after you 90 years later if they come up with the evidence. Okay. So there is no statute of limitations on a capital crime. And then finally, immunity. Why would we ever give someone immunity? Well, I'll say this. I think that the criminal justice system as it now stands is basically built on immunity. Why would I say that? Because the way they make the big cases is by flipping the little guys, getting them to testify. How do you convince this guy to testify against the general, the boss, the godfather? Okay, how do you get him to turn? You pay him money? No, you can't do that. Then what do? You catch him in a crime that he committed. You threaten him with lots of jail time that he's going to serve. And then you offer him a way out. And you say, we'll give you immunity in exchange for your testimony. If you testify against Don Corleone, we will protect you in witness protection and give you immunity. You won't have to go to jail for what you did. Did he commit these crimes? Yes. Do we have evidence that can prove it? Yes. Does he deserve to go to jail? Yes. Well, then why isn't he? Because he has the defense of immunity. Let me just say this. Get it in writing. Okay? Get it in writing. And make sure you get it from everybody. Especially if you're involved. I'm saying you, but you know what I mean. I'm talking about like a cousin or something. You know, that's kind of, all right. Because just because the state gives you immunity doesn't mean you have immunity from federal prosecution, as we're about to see. All right? Those are the defenses. Now, Fourth Amendment protections. Search warrants, the officers have to have probable cause. Probable cause is probably like 15 or 20% sure. Remember on the scale I put up here the other day? And I said preponderance of the evidence is right here at 50+%. And then beyond a reasonable doubt is like 95%. Well, what is probable cause? 15, 20, all right? And so what's even lower than that is reasonable suspicion. That's like 5 or 10, okay? So a policeman's walking down the street. You look kind of suspicious. He has a reasonable suspicion. Okay. Hey, just wondering how you're doing today. He starts a conversation with you. You get all shifty-eyed and nervous, and now he sees the shape of some drugs in your pocket. You know, and they always say that. Well, I saw what there was a clear outline of a crack pipe in his pocket. You know, and I thought, how tight are these people's clothes? You know, and so that gave him the right to do a pat-down search, which leads to other things, and that's how he ends up finding the drugs. And so in order to go into property, to go beyond the gate, to go beyond the door, or electronically to go beyond the firewall, they must have a search warrant. The Supreme Court this last week just did a major one. Did anybody catch that? A major clarification on what kinds of things they have to get a search warrant for. Anybody notice that? GPS trackers on vehicles. The police had been installing these little tracking devices underneath the body of the car, and then they didn't have to follow you. So, you know, they've been doing this in the movies for a long time. Well, evidently the real-life police said, hey, we got to get us some of those Batman toys, you know, and so they got one, and they put it on a guy, and they followed him for 4 months. I don't know if it had like a nuclear battery. I can't get anything to last like 2 days. I don't know how they got a 4-month battery. But they tracked the thing around for 4 months and all this, and they just watched him on the screen, you know, where he was going, and they saw he was committing crimes. So they used that to prosecute him. He now appeals and says, hey, did you guys have a search warrant? Did you have a warrant to place that tracker on my vehicle? They said, we don't need a warrant. It's on the outside of your vehicle. Your vehicle was in public. We just installed it. Supreme Court said, no, you've got to have a warrant in order to do that. The Bush administration, back under the first Patriot Act, they were doing warrantless wiretapping. And they said, we'll listen to all your phone calls, and then we'll be the ones to decide if they're relevant or not to terrorism. And if they're not, then we won't listen anymore. But if they are, then we'll keep listening, and we'll put it in the federal database. And some people said, I'm not comfortable with that. And they said, well, you know, are you comfortable with terrorists? You know, terrorists. And you're supposed to just lay down your civil liberties whenever they say terrorists. And the answer is, well, wait a minute. There's a price here for all of that protection. Let's don't necessarily go there. There is a way for them to get authorization to come into your house, to listen to your phone calls, and to track your vehicle. And that way is getting a warrant. Now, there are exceptions to this. Most famously is called hot pursuit. All right, so if they are pursuing someone and he's just robbed a bank and they're huffing it, you know, you see on the police shows they're always out of shape eating a donut. And the next thing they're running for 7 miles, and I'm thinking that's not realistic. You know, they're jumping over fences and from one building to the next building, and I'm thinking I want to do that. You know, how come lawyers never get to do that? You know. Very limited situations when lawyers need to run, you know. Something has gone very wrong in your career, Kevin, if you ever have to run. Okay, so just a little little tips, for your practice. I should write a book. And so they're running after the perpetrator, and he dodges into a building. And they barge through the door, and they go after him, and they tackle him. And he says, "You didn't have a warrant to come in here." "Well, I didn't need it. I was in hot pursuit." Okay. Another one is exigent circumstances. Okay. Exigent circumstances exist when the police hear a crime being committed inside an apartment, and then they kick down the door. You ever actually tried that? Not nearly as easy as it looks. You can break your foot doing that. All right. Don't do that. Leave that to the trained professionals. Or get one of those big battering ram things. Those are cool. Anybody have one in their trunk? I've always thought that'd be good. Hey, grab the battering ram out of the trunk. What? Or you're driving with somebody. What's that clanking around? Oh, it's my battering ram. You never know when you might need it. Exigent circumstances may exist. And they go grab that, bust in the door. Do they need a warrant for that? Judge, pretty sure someone's being killed in this apartment. Oh, okay, well, I've got a little opening. You can come and we'll have a hearing at 4 o'clock on that. No, we have to save their life. We need to get in there right now. It's an emergency. Well, what always happens is they bust in. Oops, it was the TV. Right? And we thought someone was being murdered. They just had the volume up high, and it was Law and Order. Okay, and we didn't hear the cha-ching. All right. Well, the problem is now we're in. And now that we're here, there are drugs laying everywhere in this place. And we say, well, we can't ignore what we see. I mean, yeah, we were wrong about why we came in, but we can't ignore what we see. And so do we have to, or it's in plain sight now? Well, no, they don't have to ignore that. They can actually go after it. All right, so search and seizure in businesses, you still have to have a warrant to come in and search through the files, although there are certainly some forms and things that the government requires you to file, especially if you're in the drugs industry, the legitimate drugs industry, I should say. Who's got this Moon case? Who's got that one? Okay, Ben, what was going on in the U.S. versus Moon?
Moon was a physician in Tennessee. She had a regular practice, but she had a contract with the state and federal program called TennCare, which provided insurance for uninsured people. She also routinely used chemotherapy for her patients for cancer. And the Tennessee Bureau of Investigation received a complaint that she only was using partial doses but billing for full doses. The Tennessee Bureau of TBI came in and wanted to see the files and scan things, and she basically...
All right, so did they come in while it was closed down and search through it with flashlights? And no. They came during the business hours, and they did what?
They asked her.
They asked her, okay, hey, Dr. Moon, can we look through your files? And she said, absolutely not without a warrant and my attorney present, right?
No.
What did she say?
She said, here they are, here's where you can scan them.
Sure you can, no problem, right? And then, of course, later, they actually found evidence that she was doing exactly what they were investigating, and they prosecuted her. And her defense was, you didn't have a warrant. How's that defense going to work?
Not very well.
Not very well. If you give consent, knucklehead, you can't then turn around and say they needed a warrant, okay? And by the way, the police always ask. And I don't know about you, but the police have a way of asking in such a way that you really feel like saying yes. I used to drive fast when I was younger, and I'm not saying I don't now either, but when I was younger I did, and I'd get pulled over on a somewhat routine basis, and they always invited me back to the car. I don't know why. I mean, hey, come on back to the car. You want to? Yeah, sure. Why do I say sure? No, I want to sit here. Why do I want to come back to the car? So, all right, so I go back to the car. Where do you want me to sit? Oh, you can sit in the front, right up here. Oh, okay. So, I'm sitting in the car. They're running my stuff. This happened to me 3 times, at least 3 times. Different states, different people. I don't know. I'm on a network or something. And so I sit there. There's the shotgun, Nice gun. Yeah, you like that? Mm-hmm. Yeah, well, you keep driving like this, you're going to see a lot of that. And I don't know what why did I go back in the car? Because just the way he said it. He was asking, but it didn't seem like a question, And so, yes, I'm good. Yeah, if he'd asked me, open the trunk, would you like to open it? Yeah, I was going to ask you if I could open the trunk. Yeah, that'd be great. How about the seats? You want to pull the seats out? We're like, yeah, sure, man, no problem. About the panels on those doors. Yeah, those been on there a long time. We should take those off. They're asking, And all of a sudden they find, drugs. Oh, those aren't my drugs. I don't know where those came from. Hey, you can't search my car. Look, you gave consent, okay? And now, that's not to say that they weren't a little pressuring in the way they were asking. They can't be overly pressuring, but don't kid yourself. When they're asking, you kind of want to do it, right? Because you feel like, hey, they'll say, it's going to be a lot harder for you if we got to come in here with a search warrant. We're going to turn this place upside down. But, we'll just be glad to tiptoe through a few files, and we'll be very careful to put everything back if you give us consent. Oh, well, okay, yeah, go ahead. And by the way, everybody's a gambler, all right? They're all gamblers. They all lie. They're all saying, oh, yeah, sure. Why do they say sure? Because they're hoping that maybe by bluffing, they'll think, oh, well, if he gave us consent, then he probably is innocent. Let's go, guys. We're just testing you. Everybody thinks that's what they're going to say. They're not. They're going to come in and they're going to look at everything, all right? And so if you don't feel comfortable with it, don't give consent, because if you give consent, it's over with. Yeah.
If they ask for consent and you say not without a warrant, is that kind of an admission?
No, it is not an admission to simply assert your rights. And you need to do that, okay? You need to shut your mouth and say, you know what? I don't really know what you're looking for. Here's the thing. They know the rules and you don't. They know what they're looking for and you don't. So, yes, we want to be cooperative with the police. As my dad always used to say, the police are our friends. Yeah, they are our friends. They even invite you back to the car sometimes. But, nothing ever came of any of that. I want you to know I'm not a criminal, all right? So I passed all my character and fitness reviews for 3 different bars, all right? I have no problem. But, no, they know what they're looking for and you don't. So it's absolutely fine to say, you know what? I don't feel comfortable telling you yes or no about that. I'm going to contact my attorney. I'd be more comfortable with them there. And then, of course, it gets a little chilly after that, all right? I'm going to skip a few things just for the sake of moving on here. Turn over to slide 15 if you have that one. And we'll talk about the exclusionary rule. So if the police break the rules, what is the consequence? Do we fine them? Do we suspend them? Can we sue them? Well, not really. The exclusionary rule is what we come up with. And it's a terrible rule, okay? Because by definition now, a guilty person that everybody knows is guilty is going to go back out on the streets and probably commit more crimes. Why? Because the police messed up. Why in the world would we do this? Why is this the remedy? I'm asking because I don't understand it either. All right? This is what we came up with. We said, well, these police are good people, and the only thing that motivates them is catching criminals. And so we're going to release criminals if they mess up. And we're going to make it so complicated and so tie their hands in doing their jobs that we'll actually put guilty people back on the streets if they mess up. That's what the exclusionary rule says. And it also says, even if you mess up and get in there and other things that are legitimate evidence come from what you learned illegally, that's fruit of the poisonous tree, and that has to be thrown out too. And so the police are left to now, but here's the fun part. If I was a policeman, I'd like it if somebody else messed up and all that got excluded. Because here's the thing. Now you're no longer wondering who did the crime, right? You actually know who did the crime now. All you have to do is find the same evidence you know is out there, but a different way, an untainted way, right? So the question in case 6.2, who has that, Anna? All right, was what if the search warrant itself was a mistake, but they actually find illegal stuff, right? So give me in like 20 seconds what was going on in that case.
Well, the warrant clerk lost in a way on the warrant for a few arrests, and the Coffee County arrested a Herring and a search went out saying he had meth and
Okay, so here's this guy Herring, and he gets pulled over, and they call back to dispatch and say, hey, has this guy got any warrants outstanding? And dispatch from another county says, yeah, we've got a couple of warrants on that guy. But it come to find out those warrants had already expired, but they made a mistake. And so they went ahead on the basis of that dispatcher's mistake, they went ahead and arrested the guy. And when they did, what did they find? They found drugs, okay? And so he got busted for possession of drugs that he really did have. So he tried to argue exclusionary rule, right? Fruits of the poisonous tree. You didn't have a warrant. You had no reason to actually arrest me. And so when you arrested me, if you never would have arrested me, you wouldn't have found the drugs. What did the court say?
He was not.
They said no. This is one narrow exception to the exclusionary rule. It was an innocent mistake, and it wouldn't help anybody. They wouldn't do anything differently if we applied the rule in this case. All right. Look in your book for the rest of that stuff, especially those constitutional protections and the Miranda rule. I'm sorry we didn't get much to that case. It's a good one, too, isn't it? All right. See you next time.